I'm Brett Panter with the personal injury and medical malpractice law firm of Panter and Sampedro. I'm here today to talk to you about the recovery of a wrongful death and the medical malpractice exception. To understand the exception, we must first discuss the general damages allowed under the Florida wrongful death statute, which is Florida Statute 768. Survivors may recover the value of lost support and services for the wrongful death of their loved ones. In determining these damages, joint life expectancies of the survivor and the decedent may be considered. Number 3 in the statute, which refers to minor children of the decedent, which is under 25, and all of the children of the decedent, if there is no surviving spouse, may recover for lost parental companionship, guidance, and for mental pain and suffering. Number 4 of the same statute states, each parent of a deceased minor child may recover for mental pain and suffering if there are no other survivors. Each parent of an adult child may also recover from mental pain and suffering if there are no survivors. Medical and funeral expenses are recoverable. Loss of earnings, less lost support of survivors, loss of prospective net accumulations of an estate, and evidence of remarriage is considered of the decedent spouse is admissible also. Number 8 of the same statute says, damages in sections number 3 shall not be recoverable by an adult children, and damages in section number 4 shall not be recoverable by parents of an adult child with respect to medical negligence. What does all this mean? How does this affect your rights to be compensated for medical negligence? Let's discuss section number 3 first. If your mom or dad dies due to medical negligence and they're not married, or their spouse died and you as an adult child, no matter how close you were to your surviving parent who now became a victim of medical negligence, have no claim for mental pain and suffering due to this unfair and arbitrary exception of the wrongful death statute. Doctors and hospitals have a statutory immunity for their negligence. Now let's discuss section number 4. If your adult child, meaning over age 25, dies due to medical negligence, you cannot bring a claim for your mental pain and suffering. If the case has minimal economic damages, which is common, the doctor in the hospital escapes accountability once again. Here's what you can do. Be informed, speak to all the elected officials, and bring these unfair, arbitrary exceptions to their attention. Ask them to change the law. If you have any questions about these laws or any other laws that affect you and your family's rights to be compensated for medical negligence of doctors and hospitals, feel free to contact our law firm via our website at panterlaw.com or our office telephone number here in Miami, Florida, 305-662-6178.